I'm last, right?
You are last.
Right.
We're going in order.
Good morning. I'm going to take advantage of this slight lull in the conversation and introduce myself. I'm Kate Bartlett. I'm Dean of the Law School, and I'm very pleased to welcome you here this morning to the fall symposium of the, I always have to look at this, Center for Genome Ethics, Law, and Policy. We call it GELP. Well, I'm pleased to welcome you to GELP's seminar in Commercialization of Human Genomics. I'm absolutely delighted that the law school can be the one to host this conference. GELP is a core component, as many of you know, of Duke's Institute for Genome Sciences and Policy, IGSP. Many universities have started centers or institutes to study genomics. Duke's involves an investment of about $200 million and will be one of the best and most important, not only because its medical researchers and its scientists are leaders in the field, but because through GELP, the Institute is one of the few to link genomic sciences to policy, law, and ethics, and to the training of students, researchers, public officials, and the public. As evidenced by those who are in attendance in this room right now, GELP is a very interdisciplinary entity. While this center has been in existence for a little over a year, it has been extraordinarily active in developing programs and seminars for clinicians, scientists, engineers, ethicists, philosophers, legal scholars, policymakers, business experts, virtually from every, I'm sure I've left out a few categories, but virtually from every corner of the university. This past July, GELP was very fortunate to recruit its first director, Robert Cook-Deegan, who is near the front of the room.
Here.
And under Professor Cook-Deegan's leadership, this center will become even more of a force in university research and debate and in the national and international discourse about the policy, law, and ethics of genomics research. Now a little promotion of the law school. I am very proud to say that GELP has especially close ties to Duke Law School. The chair of the center's steering committee is Professor Clark Havighurst, who's found a seat way in the back of the room on my right. And numerous professors from the law school have been involved with center-sponsored events and activities, including James Boyle, who's on the panel here this morning, Dorian Coleman, Jim Coleman, Lauren Dame here in the front, who was one of the masterminds of this conference. Karen Magri, who I believe is on a panel tomorrow, Jerome Reichman, ditto, William Van Alstyne, Jonathan Weiner, and many others. Every advance in genomic sciences appears to raise a whole host of legal issues, and we're really lucky, I think, at Duke to have legal scholars who can join the scholars that we have in other departments across the university to engage one another and attempt to address these issues. The need for cross-disciplinary analysis is particularly compelling with respect to this weekend's topic on the commercialization of human genomics. As we all know, genomics began as a public domain science project, the Human Genome Project, but has become the focus of growing private investment. One particularly interesting set of issues raised by this combination of publicly funded research and private industry involve intellectual property law. What are the appropriate legal limits on proprietary uses of genomic knowledge, of new genetic material, and of biotech inventions? How should the law develop criteria and standards for an optimal mix of public and private ownership? And what legal rules will ensure a fair distribution of the fruits of the genomic revolution? These are some of the most important issues of the day, addressed here today and tomorrow by some of the most innovative, forward-looking, and interdisciplinary scholars who are attending to these issues. This is really going to be a fabulous conference. I'm glad you could all be here to enjoy, learn from, engage, and challenge our speakers and one another. Again, welcome.
Good morning. I'm Lauren Dame. I'm the Associate Director of the Center for Genome Ethics, Law, and Policy. I want to welcome you to the conference. We have wanted for some time to hold an event dealing with the commercialization of the human genome. And when Dr. Craig Venter was invited to give the Boyarsky Lecture in Law, Medicine, and Ethics, we thought it was a perfect opportunity to combine the two events. Our original idea was to have an afternoon workshop with a couple of speakers who might provide some different perspective on some of the issues that Dr. Venter might discuss. As we started talking about possible speakers and topics, our list grew, and we soon had 2 panels and then 3. And then I think Bob Cook-Deegan pointed out that there was always Saturday, and we ended up with 4 panels. So I think it shows how interesting this issue is, how many different people have to be heard from in order to resolve and analyze these problems. And I think it's going to be an exciting conference. Of course, another interpretation could be that it takes 13 speakers to provide perspective with one Dr. Craig Venter. I hope you'll all go to his talk tonight. I think it will be a perfect end to an interesting day. Before we turn to our speakers, I have just a couple of housekeeping issues. The first is that the symposium is being videotaped and webcast. So by sitting in the audience, your picture may appear. So you should at all times look very interested. In addition, we hope to have a fair amount of time for questions and answers and discussion at the end of each panel. And at that time, the little black dots on the table, which are microphones, will be turned on. 2 things about this. Please do not whack them and say, "Is this on?" They will be. And don't drag backpacks across them. They also will pick up anything you say to your neighbor, and that will be webcast. They're very sensitive. After the panel, we have lunch. It's very informal. There are tables out here on the 3rd floor, and there are additional tables up on the 4th floor. This floor that you come in is the 3rd floor. So I'll now turn to our, I mustn't forget. I want to thank several groups who helped with this conference. The Institute for Emerging Issues and the Keenan Institute for Engineering, Technology, and Science at North Carolina State University. The Duke Law School, which has been wonderfully helpful. The Keenan Institute for Ethics here at Duke. And the Duke Law Students Intellectual Property and Cyber Law Society. Finally, there were many individual people who helped. I won't name them all because we're going to keep on schedule here. With the exception of thanking Susan Booth, the administrative coordinator at the Center for Genome Ethics, Law, and Policy, who has worked tremendously hard pulling this all together. Our first panel is entitled The Political Philosophy and Economy of Intellectual Property. This will help provide some background and lay a foundation for what's to come for the rest of the symposium. I hope you have all had coffee. We have wonderful speakers. They're going to stretch your mind. They're going to be talking about ideas, and some of the ideas are even going to be abstract ideas. Our moderator is Noah Pickus, who is the director of the Institute for Emerging Issues, which is an initiative of the Keenan Institute for Engineering, Technology, and Science at North Carolina State University. He is the co-author of the report, Biotechnology and Humanity at the Crossroads of a New Era, and there are extra copies outside on the table if you want to get one, and co-author of Idea to Product, an outline for discussing the roles of government, universities, and the private sector in the development process. Professor Pickus has consulted for a variety of public and private organizations. He is a member of the North Carolina Task Force for Genomics and Public Health and director of the 2003 Emerging Issues Forum, Jumpstarting Innovation, Government, Universities, and Entrepreneurs. Professor Pickus received his PhD from Princeton University, and he used to teach at Duke, and we're very happy to have him back here with us today.
Thank you, Lauren and Dean Bartlett. It's great to be here. Those of you in the field will, I'm sure, be shocked to discover that some people think that intellectual property is a dry subject. It's not going to be today. And it's also clearly important that despite some folks finding it dry, it's about as central an issue as you can find to a whole range of issues, from what makes this new, what are we calling it now, new old mixed economy, to democracy in repressive regimes, to scientific innovation, to human health. The list goes on and on. And this is especially so when we talk about genomics, when we talk about issues especially at the intersection of the economic and the social and the legal dimensions, which biotechnology forces us to confront perhaps like no other issue, as is witnessed by none other than Craig Venter deciding to get heavily into the ethics game now. But you can capture it pretty easily, right? Hogs into humans, tobacco into cosmetics, food as medicine. It's getting pretty mixed up in lots of interesting and important and life-saving, but also scary and dangerous ways. So the symposium here today doesn't really need much to be said about its importance. It's clearly front and center. Let me say a couple of brief things. First, to borrow from James here, that at least a piece a few years ago, which I still think is true, that we don't yet really have a politics for the information age, that we're still groping toward that in many ways, and a lot of the IP issues are dominated in so many ways by the major players. And it is therefore particularly critical that scholars and smaller entrepreneurs and others weigh in on these issues and be given vehicles to weigh in on these things. At the same time, let's remember that just because we weigh in doesn't make the answers any more obvious. In fact, it can make them harder. I told James I was going to steal from a piece of his earlier where he quotes Northrop Frye, the literary critic, saying something to the effect that poetry can only be made out of other poetry, novels out of other novels. And so even on market grounds, there are questions here about the conflict between incentives needed to develop new drugs and drive them into products and the availability of ideas needed to do the same thing. And as Alex Rosenberg here has pointed out, there are broader questions and messy questions, regardless of what you think about intellectual property, about international institutions and what they can do. Can they be designed to actually provide developing companies with an incentive to protect intellectual property? This panel is designed clearly to start us off into these messy issues by digging first deeply into some of the philosophical bases of intellectual property and to ensure that we don't too quickly jump into competing interests. At the same time, all of these panelists have been engaged in these issues with regard to realities, competing interests, and market conditions. In particular, Max Wallace here, as you'll hear in a moment, has been involved in this for 20-plus years with companies. You have in your program a description of some of the broad questions that Lauren and others have set for this panel. Let me just make one last note, and that is to say that I think this symposium and the projects in and around it that the center is developing and lots of other organizations are especially of note here in North Carolina, because North Carolina has some special qualities here. First and foremost, we have in our national representatives, we have in Howard Coble, the chair of the subcommittee of the Court's Internet and Intellectual Property. Pretty important to what we're doing. And in David Price, our colleague from across the street, a congressman well-schooled in ethics and public policy. And of course, in John Edwards, we have a lawyer. What I do want to point out here, Lauren has kindly called attention to my own institute's small contribution to this, our report on biotechnology, dealing with issues here in North Carolina. It's available outside. And I would just end with this point, and that is that we have a remarkable opportunity in North Carolina, given the concentration of biotechnology companies and universities and representatives, to really make a mark in this field. in lots of different ways, and we have an opportunity to take that up today and to push it forward. I will stop now and introduce our first panelist, who is Alex Rosenberg, a professor of philosophy at Duke, where he joined the faculty in 2000. Alex has previously been a professor of philosophy at Syracuse, at UC Riverside, and director of the honors program at the University of Georgia. Professor Rosenberg has also been a visiting fellow, professor and fellow at the Center for Philosophy of Science at the University of Minnesota, as well as UC Santa Cruz and Oxford University. His interests focus primarily on metaphysics, mainly surrounding causality, the philosophy of social sciences, especially economics, and most of all, the philosophy of biology, and in particular, the relationship between molecular, functional, and evolutionary biology. He serves now as co-director of the Duke University Center for the Philosophy of Biology and is a member of the steering committee for the Center of Genome Ethics, Law, and Policy. Alex.
Thank you. Hold your applause. There'll be a quiz at the end of my lecture. Well, we're starting with philosophy, as Noah said, to set a framework. And so I'm going to give a mini lecture, and as a philosopher, of course, I've got my own opinion. I'll end with that. There are two traditional arguments for private property. The Lockean argument from natural rights, from the natural right to private property, and the traditional utilitarian argument for private property as a solution to the tragedy of the commons problem. These two traditional arguments for property are particularly appropriate in the case of intellectual property. When you think about Locke's argument for private property, it was that private property was morally permissible under two conditions, or maybe three. If you mixed your labor with nature, and if you left as good and as much of nature to others, then that part of nature with which you mixed your labor was morally, rightfully yours. Of course, one of the problems about original acquisition, as it's called, is the problem of satisfying the proviso of leaving as good and as much for others, a proviso almost impossible to satisfy in the case of real property, but a proviso particularly easy to satisfy in the case of intellectual property. Because what a scientist or an inventor or a discoverer does in mixing their labor, their cognitive labor, with nature to produce a new idea, typically does leave as good and as much for others, since there are indefinitely many good ideas still out there. I won't talk much about the tragedy of the commons problem. I take it that in this audience it's fairly well understood. But I think there's a third argument for intellectual property, for the propriety of it, for the moral foundations of intellectual property. And the argument is so powerful, in my opinion, that it shifts the burden of proof onto the shoulders of those who oppose strong intellectual property protections, particularly for the results of genomic research. So I think, in fact, there's a strong prima facie argument for giving the biotech industry almost everything that they want by way of patent protection. I do reserve the weasel words almost, so that I can retreat in the face of good objections from the audience. The argument is very simple, and here's the premises. The first premise is that human welfare is enhanced most easily, most directly, by producing more and more of everything that people want, including new healthcare products, for example. Seems a relatively uncontroversial premise. The second premise comes to us from economic theory, and it's the claim that of all the factors of production, all but one are subject to decreasing returns to scale. That is, after a certain point in production, the addition of another unit of land or labor or capital does not result in the production of an equivalent additional unit of output, except for one of the factors of production. This one factor of production is not, unlike all the others, subject to decreasing returns to scale. And that factor of production is good new ideas, intellectual innovations, discoveries and inventions that enhance the productive power of land, labor, and capital. So the only exception to the law of diminishing returns is new ideas. And in particular, as we noted in the case in thinking about Locke, the number of new ideas is indefinitely large. Indeed, for all intents and purposes, infinitely large. And they're all out there waiting to be uncovered and to have a productive effect in the provision of those goods and services that enhance human welfare. Conclusion, or at least the first conclusion from these three premises. No impediment should be placed in the way of the production of good ideas. And every incentive required to encourage the provision of these good ideas should be sought. So what are the corollaries? Well, the first is that the best incentive to the provision of new ideas is to privatize them or to allow them to become private property. Now, when I say best, I recognize that, of course, the patent system as a way of encouraging the production of good ideas up to as close to the optimum level as we can get is imperfect. It is what the economists call a second best solution. It's a second best solution because it accords to the patent holder a monopoly. A monopoly we know is bad. Those of us who have taken microeconomics can point to that little triangle on the graph called the consumer's surplus, which is lost, and lost irretrievably by the granting of a patent. But unfortunately, no one has conceived of an alternative to the patent system as a way of incentivizing the provision of new ideas by harnessing the market to the incentivizing that we require. So it's the second best. It's the best among the second best solutions. And that means that the only issue in intellectual property protection is not whether intellectual property should be protected, but how much. And the argument that I've just appealed to from the non-diminishing returns to scale for intellectual property by comparison to everything else suggests that it ought to be protected very strongly. Now, unfortunately, protecting intellectual property very strongly has certain negative externalities. Okay? Costs imposed on others, okay? Consumers, producers, society at large. And it's likely to exacerbate the inequalities of wealth and power that already exist in our society, and therefore to produce more and more cases of market failure of various sorts. I mean, the case that I think of most pressingly that made the headlines over the last year or so is the conflict between the government of the Republic of South Africa and the makers of the antiretroviral drugs, say that 3 times fast, in regard to the price which these companies insisted on charging for the drugs and the availability, particularly by Indian manufacturers, of generic knockoffs of these drugs, which led the Republic of South Africa government to seek, in a court case, in fact, to force the manufacturers, the international big pharma manufacturers of these drugs, to lower their prices. That's an example of one of the externalities that's produced by giving very strong intellectual property rights to the owners of, say, pharmaceutical drug designs. Well, the solution to this problem, if we accept the argument that I've given about the importance of intellectual property as a non-diminishing returns to scale factor of production, is not to curb or to otherwise limit the rights of owners of intellectual properties, but rather to impose swinging taxes and other kinds of restrictions on the rest of property, on real physical property, on wealth, on income, on land and labor and capital, in order to compensate those who might otherwise be harmed by the imposition of very strong property rights on intellectual property. So the background of all of our conception of these problems is that we have to deal in trade-offs. Okay? And if intellectual property has the particular economic characteristics that I've identified, then in thinking about the trade-offs that we need to undertake in order to satisfy demands of social justice nationally and internationally, while at the same time enhancing as much as possible the level of human welfare of our society and every other society, then in thinking about that balance, the burden of proof is on those who believe that we ought to attain that balance to restrict intellectual property rights. And the prima facie case is in favor of those who think that we ought not, and that where they result in unfavorable outcomes elsewhere, we ought to take steps elsewhere in the control of land, labor, capital, and wealth to compensate for the unfavorable effects of such strong intellectual property rights. That's about all I want to say. I think that there's enough food for thought, if not for refutation, in what I've said.
Thank you, Alex. We got interesting definition of market failure on the table. Now we go to market success. Max Wallace is president and CEO of Cogent Neuroscience, Inc., a local biotech company. Mr. Wallace, Max, has been involved in the creation and development of successful biotechnology companies for more than 15 years. Prior to co-founding Cogent in '98, Mr. Wallace co-founded Sarco, dealing with small molecular combinatorial chemistry, in 1996. Trimeris, many of you know for its work on viral fusion inhibition, in 1993. And Sphinx Pharmaceuticals, dealing with cellular signal transduction, in 1986. At both Trimeris and Sarco, Mr. Wallace served as president and as a member of the board of directors. Sphinx Pharmaceuticals had a successful public offering and was subsequently acquired by Eli Lilly and Company. Trimeris had successful initial and secondary public offerings, and with partner Hoffmann La Roche is moving its first two anti-HIV drugs through clinical trials. Sarco was acquired by PPD Pharmaco. Founding management director of Duke Management Company, Duke University's asset management company, Mr. Wallace received his BA from Duke University and his JD from the University of Florida. And forgive me, Max, I can never resist saying when we first moved to North Carolina, I took a class from Max called How to Buy a House in the sort of Duke extension, I think it is. It's many years ago, and we're still in the house for better.
Well, thank you, Noah. I'm flattered, actually, to have been asked to appear here. I am part of the effort, I think, to get cross-disciplinary representation, and I've always tended to think of that as a horizontal kind of range of disciplines among scholars. Here, I think now we're kind of playing three-dimensional chess. I am not quite a scholar. I'm unencumbered by that problem. I'm not a scientist. I'm certainly unencumbered by that. What I am is a person who has figured out in some pretty guerrilla warfare type of ways how to make some enterprises come to life, keep them alive, and then have them produce useful things. I laughed when we started Cogent. All of my companies, frankly, have been spin-outs of Duke University, where I do work with smart, scholarly researchers who have dedicated their career to these things. I'm the technician and handyman who helps bring certain aspects of it to life. But when we started Cogent, there are two really hard things that you need to do. One is figuring out a name for a biotech company. You know, all the Greek gods have been taken, all these other things. And actually at Trimeris, we made it up finally. We did an Exxon type of gig. Cogent, I was driving by the Lucent plant on I-40, and I knew that we had talked about the brain as terra incognita, and we were going to make it known. You know, it's going to be cognita, but it sounded like a Puerto Rican prostitute. So I was actually driving by Lucent and said, well, Cogent, even though as an English major, I know they're not even the same root words, it sounded good, you know, Cogent Neuroscience, and we could use initials like CNS if we fudged a little, so we did it that way. And then you kind of tend to think of what's your mascot, and you would like some raptor or something noble, you know, as your mascot, because logos are very important. And I had this problem. I grew up in South Florida. That's why I went back to University of Florida for law school. That and that I'd had a good time in undergrad and couldn't have gotten into Duke Law if I had bribed everybody here. But I tried to think what our real mascot should be, and it came to me that it kind of spun from my career and that it was the state bird of Florida, and that was the cockroach. That My career skill, I think, is that I have perfected the art of being a cockroach in an entrepreneurial economic environment. And so I am here in a truly cross-disciplinary way because I would wager that I am probably the one token cockroach in the room, and I know I am certainly the one token on the panel. I was a little worried that I was here to be considered kind of the heathen capitalist pig cockroach that would be slaughtered by smart people sitting up here. I never thought that I would have the marvelous opportunity to speak second and be viewed as a moderate. You know? So I thank you very much, Alex. You've made my job marvelously easier. I'm here, though, to probably give you the cockroach eye view of where intellectual property plays out on the biotech battlefield. And it's a highly unromantic view, I'm afraid, and it certainly is not a scholarly view. It is important, however, and I want to put it in some context. I'll tell you, I'm only midway through Cogent Neuroscience. We are in Act 2, and there are at least 3 acts to this play. I have a better view back to my last company, which was Trimeris, because it's deep in the 3rd act now. We started Trimeris in discussion in 1991, where the dean of the medical school asked me to talk to Danny Bolognesi, who was an excellent researcher at the Duke Center for AIDS Research, about trying to see if there were opportunities to do something commercial with the technology that was emerging from his facility. And at that time, there really wasn't much knowledge that AIDS was going to be an epidemic. It was considered actually a named phenomenon of gay cancers as it had come out. And as we looked at it, we were actually told we should not pursue it because there wasn't a market there. That markets were determined by how many drugs had sold the previous year, and the total number that I think AZT represented was less than $100 million. And in pharma terms, that is a micro market and not interesting to anybody. I think nobody predicted what HIV infection would lead to around the world and what the dynamics would be. But we hunted for 3 years and couldn't get anybody interested in funding an enterprise centered on this, partly because of market, but also nobody in North Carolina is going to tackle that. Nobody from a university, no small company. We think it may be unsolvable, and if it is solvable, it's only going to be a world pharma giant like Merck that will do it. Well, in the best kind of cockroach fashion, I didn't listen, and it makes you more determined. You know, when people tell you can't do something, you say, well, I'll roll it up and stick it in your ear. And that was basically our response to this. And we stayed at it, and I had just about given up. But it was the first Duke basketball championship. Many of you remember what a joyous experience that was. I drove in from my house in Hillsborough just to look at the bonfires. It was a great thing. And on TVs around the United States, there were pictures of semi-naked or fully naked Duke students dancing through these bonfires. And I was working at Duke Management Company that had invested a lot of money with a lot of venture capitalists, and one of these venture capital funds was managed by a guy who had 2 daughters at Duke, who immediately became terribly scared of what was going on and used a tax-deductible opportunity to fly down and make sure his daughters were unsinged. And he came to me and said, why don't we go see this guy Bolognesi? I've heard a lot about him. I said, I've flat worn him out. I have induced metal fatigue. He will not want to talk to you. Leave him alone. Be nice. And they said, oh, come on. They whined. And it's so rare you see a venture capitalist whine. It has an amazing effect. And so I called Danny, and he had us come over. And damned if that week he hadn't made this wonderful accidental discovery in his lab where he was looking at a protein on the surface of the HIV viral particle that he thought might be an antigen and produce an immune response that could allow him to hunt for a vaccine. And they accidentally kind of threw it in a cell culture, and it stopped viral replication of HIV in cell culture. And I'd spent 3 years running around. I was ready to give up on Danny, and the venture capitalist looks at me and says, don't go anywhere. I'll fund this company. And here I had almost self-censored that company out of existence. Well, they put up $5 million to launch it, and we wound up raising $35 million to do the early work that came from venture-funded ideas based on a couple of patents that had come out of Danny's office that were licensed to this enterprise. We were indeed fortunate because despite our best efforts to look at hundreds of other potential drugs, that one peptide hung tough. First thing we ever discovered is like God smiled and said, you know, I need a new HIV drug. And I need it fast, and you'd better keep this thing on track. So the fun part about antivirals is in phase 1 clinical trials, you can actually fudge a little and get efficacy data. You can see what the viral load is in the patient's blood. Say if you reduce the viral load, that's a surrogate marker for efficacy. You can then go raise money around that, which is basically what my job is. What a CEO gets when they join a biotech company is a really good suit and a pair of knee pads. You know, you spend your entire life raising money, begging for dough. That's all I do, pretty much. And I found a path to dough with the fact that we got efficacy results after only $35 million of investment. And we were so broke that actually I had to call my banker and cover our payroll for 2 months running with a personal line of credit because our venture capitalists had pretty much worn out. And then this data came in, and 4 months later we were public. Pretty amazing, fun story. It continued, though. Past my resignation, I resigned on the night before we went public because I realized I was a founder and general counsel and member of the board of directors and the vice president of operations. And if I resigned the day after the public offering, the markets would go berserk. Why'd this guy leave? And I was pooped, so I left. But I've watched closely, and they've raised $360 million more dollars. Okay, so we went from looking at this in 1990, starting the company in 93. We are now in 2002. We've raised $390 million to advance to a point where 6 months from now, FDA willing, that company will have sales. And it was the first compound that made it all the way through. It has never happened in medical science. But what it does is give you an idea of the time frames and the relative cost of taking a discovery from basic science in Duke University out to the public. It's staggering. And my fear is that, frankly, the economic climate post 9/11, post dot-com crash, all of the bad things that have happened, post Enron, is really not going to provide some of that same bridging capability to get you, if you think that a university will take the ball out to the 20-yard line. I know it's dangerous to use a football analogy at Duke, but if the universities get the ball from the goal line to the 20, pharma doesn't really want it until over midfield. And as they've gotten into earnings problems, they actually want it way deep in their own half of the field because they need products now. To support pharma stock prices, they need 3 new chemical entities a year entering trials, and the average is about 0.8. So when you drive by, I forget, it's GlaxoSmithKline, but the G is silent, right? You drive out by there and you see this giant research engine, 0.8 NCEs a year out of that machine. And so they're buying the last vestiges of innovation that other people have done, but nobody's really kind of moving back. There's not a lot of capital to move it forward in that 30 to 40 to 50 yard space that now sits on the other end of universities. That's where I'm living right now, and it's horrible. You know, we were a genomics company. We set out to decipher the genome of the brain. We were the world's first neurogenomics company. And it was great until Clinton Blair opened their mouths and started the cascade that in the end put the genomics revolution to death. It coincided with the dot-com crash and all the other things we talked about. But I get walloped by my investors because my post-money $30 million market cap that was true in April of 2000 is now a pre-money $15 million market cap as I try to raise money. The way I make them feel better is I have collected a database of all known genomics companies where I could track value back to April, and the average genomics company is worth 4% of what it was then. So my 50% value looks great. Genomics doesn't exist as an industry per se. You can't sell genes to people easily. What you can do is use them as tools to become a pharmaceutical company, find targets with them, find what they do, see what use you can make of that type of information to become a drug company. Because in the end, the product that sells for billions of dollars coming out of all this biological science generally is a drug, a chemical, something that people find useful to cure the ills that scare us all. So we have morphed over a 4-year time frame from a genomics company that we thought would have great value now to a drug discovery company that is using genomic information as part of a high-end way to move forward. As we look at this, the role of intellectual property for us as kind of a pragmatist in this process is multifaceted. One, it is something that venture capitalists use as a surrogate for value. that they don't know how to evaluate what we do. Even if they have PhD scientists on their staff, they can never have enough PhD scientists on their staff to evaluate each discrete opportunity that is the bleeding edge of that particular field of science. So they've got generalists, in essence, and one tote board marker that they put up is how many patents do you have? As if that's really worth something to you, but that is a crude marker, and the average venture fund sees 1,000 companies a year, reads 100 business plans through the executive summary, reads the entire business plan on less than 50 and makes less than 10 investments. So surrogate markers are their key, and intellectual property is this kind of bogus surrogate marker that they use for valuation. Then, as we go forward, it's a scorecard of whether we run good science, that we're doing something. We're under pressure to generate patents, and that's a totaled up thing for us. It's a marker of progress that your board of directors use. I don't think it's a very accurate marker of progress, but it's there. Third, it is used as a weapon. You know, it's an axe that I can wield. If somebody gets a little too close to my space, I can back them off. And in fact, with Trimeris, for example, we were so novel that Burroughs Wellcome, the other major antiviral company in the world, was starting to sniff around, and we started to waive our patent, and they backed off and talked to us about collaborating, because if they'd tried to steamroll us, our greatest fear, it's kind of like the Ford Pinto litigation. The damages would be so intense if they got caught that it was easier to deal with us. So it was a useful threat that I could back them off with. I knew I could never use it. I couldn't afford to use it. I mean, no company has money to pursue patent litigation against a much bigger company. But still, that little private attorney's general concept of the plaintiff's attorney always lurks in their mind, and it drives a certain amount of good behavior, and it gives me faith in the legal system. So we use it as weapons. It allows me to publish, but I'm scared of publishing a little bit just because of competitive things. But as I've thought about it, frankly, in my space, not in big pharma space, but in biotech space, there's almost no competition. I mean, it's a terrible thing to say, but the weeding starts at funding, and they don't fund redundant companies. At most, in any given area, you fund 4 companies, 2 die quickly, one gets 50 to 75% of market share, and the other lives but doesn't thrive. So there are no other neurogenomics companies in our space. There are several other neuro companies, but they're being winnowed out. And as a result, kind of an equilibrium establishes itself, and you can't distinguish, and you don't fight your competition. I use it as trading cards now and as surrogate markers, and I do it because we're supposed to do it. I had a wonderful opportunity a year ago. Cogent invented the field of neurogenomics. We stole some .com-y stuff and said, well, if the field doesn't exist, let's make it. Well, how do you do it? It's kind of a 7 degrees of Kevin Bacon thing. Get some big dog to come to some big event and utter the words neurogenomics and Cogent neuroscience in the same sentence. Then we will be the dominant player in the field. And we use this 7 degrees of Kevin Bacon, weirdly enough, to find our way to James Watson, the discoverer of DNA. And said, dear Dr. Watson, wouldn't you like to help name a field and be the keynote speaker on the world's first symposium for neurogenomics? And when he said yes, then all the other leaders in the field of genomics came to Durham, and we had an 800-person conference out in the park. And it was great. I mean, we had Francis Collins, who has an interesting relationship with Jim Watson. We had, the only person who turned us down, actually, is Craig Venter. So I'm actually going to enjoy tonight. He was busy building Celera into what Celera became. But I had a wonderful patent lawyer that has done all my work forever named Laura Caruzzi from Penny and Edmonds. Laura's at least 4'6". Toughest person I have ever seen in my life. Just a Wolverine of a lawyer. Great, and I love her. And I have a little car, and I had to drive Dr. Watson from the opening reception at Duke over to UNC, and I had Laura in the back seat. And I was so excited that I could have my friend Laura Caruzzi meet Dr. James Watson. Since I'd never taken a science course, when did I ever think that I would drive Jim Watson anywhere? And I'm in the car, and we're going. It's this nice little intimate environment. We've all had a couple cocktails at the Wash Duke, and we're driving over, and I explain what Laura does. And he says, Dr. Caruzzi, you know what I think about patents, biotech patents? He goes, no, Dr. Watson, what? You know, she was eminently starstruck. He says, screw biotech patents. They're the dumbest thing I've ever seen. Well, we didn't have any further conversation the entire way to Chapel Hill, because he finds them so anti-competitive in a way because there are so many of them done for all these tote board things. So I think a little bit of what we need to talk about over the course of this is, are they really useful? And what are they useful for? I mean, there's an interesting dichotomy from the practitioner side to the practicing lawyer side, to the big company lawyer side, to the battles at some of the giant mountaintops over patent control. For most of us living and working in the valleys, the cockroaches, the patents that we put in place are figureheads, are things that do certain things for us that are completely unrelated to what you think they're there for. And so they're economic tools, they're indicators, markets, fundraising tools, and trophies for us to drive our companies forward on. In the end, things can be valuable to us as drugs, and that patents are just one more tool to get there. You want the billion-dollar chemical, and that's what we're after. So I'm here, as I said, to be kind of the heathen pig and represent this view, and I'll be glad to turn back over to a scholar so you get the contrast. Thanks.
Thank you, Max. Our third panelist, James Boyle, is the William Neal Reynolds Professor of Law at the Duke Law School. He has also taught at American University, Yale, Harvard, and at the University of Pennsylvania Law School. His recent work has been on legal issues posed by the commodification of all forms of information, from the genetic and cultural to electronic and commercial. His book on the subject is the wonderfully titled Shamans, Software and Spleens, Law and the Construction of the Information Society, published by Harvard University Press. His most recent article is Fencing Off Ideas, the Second Enclosure Movement, which appeared in Daedalus, the American Academy of Arts and Science Journal, earlier this year. James is a member of the advisory board of the Electronic Privacy and Information Center and the board of Creative Commons, and he is currently working on a book called The Public Domain. James?
I think I'll just use this mic, Wayne. I don't need the wireless one. Well, no one is playing to type today. The academic philosopher stood up, stayed within his time limits, and praised private property. The CEO got up and said, there are lots of patents, many of them are worthless, and they're only signals, and it's not clear what value they have. I'm writing a book called The Public Domain, so I'm going to start by talking about the value of intellectual property and why it's such a wonderful thing. Although I may end up being truer to type, because I'm going to end by talking about, I'm going to start by saying what's good about intellectual property, and then I'm going to talk about some of the specific features of the genetic revolution and of patents on genes in particular. And then I'm going to talk a little bit about what I see as some of the excesses and problems with the system. Before I do all of that, I'd like to thank the organizers of the symposium, Bob and Lauren, and also I know Alex Rosenberg and Elizabeth Quiche were instrumental in conceiving this whole thing, and I'm very grateful to be here. So let me start by saying the great thing about IP, talking about what a wonderful system it is. The story you normally hear about IP, which is true but incomplete, is that intellectual property is a way of establishing a limited monopoly on public goods, goods that are non-rival and non-excludable. I can use them, you can use them. It's hard to stop people from using them. Goods that are, in layman's terms, expensive to make, cheap to copy. And what we worry about is that if we just have somebody coming up with a formula or with a software program that can be copied for pennies, that they will do so, and that the creator won't have sufficient incentive, which would be sad for that person, but sadder for the society as a whole in the future, because no more new drugs, software programs, and so forth would be created. That's the standard story, and I think in large measure it's true. But it's incomplete. Fairly incomplete. And I think what I want to start by giving is another side of it, which I think is actually a side of praise for intellectual property, which surprisingly we hear less often. Before I go on, I should note two things about Alex's wonderful and wonderfully provocative introduction. I'm going to concentrate on the intellectual property, I'm going to work from the intellectual property system as it is in the United States. I'm also going to talk a little bit about global dimension. In the United States, and increasingly in the global dimension, the Lockean story that Alex started with, the idea of mixing your sweat with those bits or those fragments of a genome and getting to own them, is constitutionally forbidden. It would be unconstitutional for the Congress to create an intellectual property right on such a basis. This doesn't mean it's an interesting idea to think about philosophically. It would, however, be unconstitutional in the United States. And since the United States is driving IP policy worldwide, that's an important thought. This does not mean we should give up thinking about it, nor in seeing how it actually inflects decisions in the world. It is, however, important when we are starting from the existing institutions and trying to revise them. The work of philosophy that one eminent philosopher referred to as trying to rebuild your boat while you're already on the ocean. If that's your task, that's an important constraint to think about. Okay. What's this additional element to intellectual property beyond the simple limited monopoly to solve a public goods problem? I think it goes back to a sort of deeper stage, a deeper kind of worship of markets, of excitement about markets. And I want for a moment to try and make you all very excited about markets. This will come easily to the economists among you. You can generally tell the economist in an audience because you say, the market cleared. You can see them shifting in their seats happily. But I want to talk a little bit about the delights of market function. Think for a moment, how do we allocate social resources in the society? How do we decide how much energy to spend roasting coffee and making paper cups and making bottled water and making laptops and growing petunias and growing flax? How do we decide what proportion of our total wealth, total productive enterprise should be given to this? The answer in a capitalist society is a fairly obvious one. We have a decentralized system of private property. We allow individuals to basically make bets on where to place their labor and their other resources in order to get a return. If you're a farmer and you're growing lettuces and you realize you're not getting very much money, but you notice that everybody's putting pansies or petunias in their window boxes, you think, you know what, I could shift this field to producing pansies and petunias, and if you get a return, you go, aha! I'm doing the right thing. In this model, markets are actually extraordinarily complex machines for processing information. And what they do is allow us to solve a problem which no centralized society has ever been able to solve at even a minimally acceptable level, which is how to allocate productive resources, how to decide what we make, how we allocate the people, the brains, the stuff. What intellectual property is designed to do at its basic level is solve a couple of problems that might exist in the information world such that we could do the same thing, have this marvelous decentralized system for allocating energy, effort, productive resources on information and information goods. Well, how are information goods different from petunias or flax? Couple of obvious differences. The information tends to be non-excludable. If I've got the petunia, you don't have it, at least maybe until you've taken a cutting from it. It's harder to exclude someone from an idea, E equals MC squared, a particular line of research, a piece of software code. They're non-rival. The notion that I can be using it perhaps at the same time as you can, or that one unit of the good can satisfy an infinite number of users. You know, I say equals MC squared. You're not going to go out and use it up by thinking about it, right, in the same way as you would with a bottle of water. But there's a couple of other things that are really important about information goods. It's really hard to value information till you've got it. And once you've got it, then you've already got it. And so someone says, how much was that worth to you? You go, not much. Right? That's a real problem for markets to work, right? What do you have? Tell me what you have, and I'll tell you what it's worth. Okay, I've got it. It's not worth anything. Okay, what do you have? I'm not telling you. Well, I'm not giving you anything for it. These are a series of impasses, right? There's bargaining to impasse there. It's a lot harder to sell information than it is to sell petunias. Now, it turns out that in the vast majority of cases, contrary to what Alex said, we managed to solve this problem very well without intellectual property. In fact, Alex exists as a person who largely produces good ideas and does so, I am willing to bet, in a system where not once in his entire professional career will intellectual property rights ever be significantly involved in any of the ideas that he has ever produced. Blockbuster forthcoming, not, the philosophical bodice ripper I'm sure he's working on now, notwithstanding, in fact, we have massive systems, fascinating, decentralized systems for the production of information using all kinds of wonderful incentives and quasi-shadow markets in which intellectual property plays a role. IP is the exception, not the rule. So, but there are some cases where we need it. I think drugs are perhaps the single best example. If you need $380 million to get the product to market, as Max was saying, it's just really hard to see how you can do it without either creating some kind of intellectual property right, or on the other hand, having some kind of direct subsidy from the government. The government simply pays you to produce the drug. I don't really see many easy workarounds there. I'll do it purely for prestige. Prestige takes you somewhere. It doesn't take you to $380 million and a phase 3 clinical trial. Okay. So now we get the argument for intellectual property. It's not just solving the limited monopoly problem, right, or using a limited monopoly to solve the public goods problem. It's to try and get this wonderful market for processing information, the market as an information processing mechanism. It's trying to do that in the same way as we do with other kinds of goods. But it turns out, as I said, that it's much harder to do than with petunias. And again, I'm really grateful to Alex for setting this up for me. Because it turns out that there are two really easy ways to fail at an intellectual property system. The first one is to set the levels of protection too low, right? This is a great way at failing. So you say you don't give people patents on drugs, you have things that you want to produce in the world of expression, and you say, now we're not going to hand out copyrights for them. That will be a real problem. I'm against it, okay? Intellectual property is good in that situation. The second way of failing, and this is why I would claim Alex's claim that there's a prima facie case to be made always in favor of intellectual property, and the burden is on those who would oppose it. The second way to fail is to have too much of it. Imagine if the boy meets girl story were copyrighted. My son watches this show fanatically, and hence the Freudian slip. Imagine if Boy Meets Girl was copyrighted. Imagine if E equals MC squared could be patented. Imagine if the English language were owned in the same way as the Windows operating system is. Now, I'm communicating to you in a language, or attempting to communicate to you in a language, which is, at least in theoretical terms, our common property. It is free. Even with tangible property, houses, it turns out that you maximize the value of private property by having some public property. Private houses are a lot more valuable if there are public roads that are commons with which you can get to them, right? That aren't owned by anyone in particular, but are publicly available to all. And with information, this idea holds true in spades, because with information, we get to a good, the production of which, and this is unusual with other goods, turns out generally to involve dismantling things in the past. We don't generally make lecterns by taking apart old lecterns and sticking them together to make a new one. We don't generally, sometimes we do, make houses by knocking down a couple of old houses and sticking the bits together. But every day, in every way, we remake intellectual goods by taking prior intellectual efforts and adding, synthesizing, and so forth. If those prior intellectual goods, the inputs, are too highly protected, and figuring out how high too highly protected is turns out to be really difficult, then you won't get an adequate set of outputs. So if I say, hey, I'm going to give you a really high protection on your output, that sounds great until you realize that every input that you buy is similarly going to be highly priced, right? Suddenly, it's a level-setting problem. This is a bivalent issue, in other words. Too high is bad, too low is bad. It cannot be the case. This may be the only falsifiable philosophical idea ever put forward in a Duke Law School classroom. It cannot be the case that it automatically, there's a presumption that more is better, because it's a bivalent system. Too much is as bad, demonstrably, as too little. Now, there are actually more subtle arguments in favor of his position, but I'm not going to make them for him. He can do that perfectly well himself.
Maybe.
So, the IP system then, the idea of the IP system, hand out this potential prize, this sort of, piñata, hey, maybe there's a patent in there. Encourage entrepreneurs and others to make bets. They put their money and their brains and their mouths, right, and say, maybe we'll get to a patent. They're not just betting that they can get to a patent or that they will produce the thing they said they would. They're also guessing that you want it, right? It's a double guess. And that's what's hard about information goods frequently. It's not producing something for a market we know about. It's thinking, should we spend our productive energies producing those curious little yellow sticky pieces of paper that you can put on your work and then peel off without damaging the paper, Post-it notes? Should we spend money? We're guessing about the worth of the product as well about whether we can get to it. And IP is the prize that we give to the people who try to do that. The point that I've tried to make is, clearly, too much is as bad as too little. There are some other subtler problems about giving too many intellectual property rights. It is frequently wasteful to give and to set the intellectual property rights levels too low. Imagine something that the market is going to produce in time itself, maybe at a cost of about $1 million, nationwide. Like the idea that it really sucks going to used car salesmen and you don't trust them, so it would be good if there was a national chain that had pretty solid guarantees and a standard set of contracts that you would go to and people would actually trust, which would get secondhand cars to people better, okay? This is an idea that the market would have come up with. I know this because it did. The market would have come up with by people thinking it out, trying it out. It didn't cost that much money. We could have handed out a patent, and sadly today the PTO would have hand out a patent if you put the magic words "by means of a computer" into the patent application, which gave someone a patent over this. Now this would have led to a race in which lots of people would have thrown a lot of money because they wanted to be the first past the post in order to get the prize. So let's say this is a drug. Everyone's racing to produce something like this. And so instead of getting, $1 million spent over 5 years to get it, maybe we're spending $100 million over 1 year. And then at the end of it, this thing, which would have been freely available to everyone, as something which was just produced in a competitive market, is now only owned by one person. And what's more, we spend $100 million to get it, and the price is higher. That's wasteful. That's just socially wasteful, okay? So when you set patent protection too low, you can encourage races for things you would have got anyway. You can get them at an extraordinarily wasteful level, and you have all the problems associated with monopoly, all right? So there are all kinds of really complicated problems we have to solve. Now, the point that I've been trying to make here is intellectual property is good. Too much of it is bad. It's really hard to figure out how to set the limits. Let me very briefly set out some of the fundamental notions that intellectual property scholars use to analyze these issues and that form the basis for our intellectual property system, the core of which I think is very defensible. And then let me turn to the specific features of the genome. The answer to all of this, an answer which was fairly clear to Madison and Jefferson, as well as to people like Adam Smith and Macaulay, was to put the burden of proof on the people who proposed the monopoly. Macaulay says, it is the general tendency of monopolies to make things dear, to make them scarce, and to make them bad. Okay? He was influenced by the writers of the Scottish Enlightenment. This is a monopoly like any other, so show me you need it. I actually think this is personally where I would set the burden of proof, the opposite side than Alex would. So thin layer of monopoly rights, right, which you have to specifically justify. In the conceptual structure of intellectual property in the Anglo-American system, the way that we do this is to say that facts, the speed that something drops when you let go of it, the tensile strength of steel, where the Archduke Ferdinand was killed, these are in the public domain. No one can own facts yet. They're trying, but at the moment, no one can own facts. Ideas are similarly unownable. E equals mc squared. Freedom is good, right? These are things that no one can own. Although, interestingly, the phrase freedom of speech has not one, but 5 trademarks on it. Never mind. The facts and the ideas remain in the public domain for all to use. The common property, the roads, if you will, that we use, okay? In between these facts and ideas is a layer of expression on the one hand, the novel, right, the film, the painting, the Britney Spears, and of inventions, the mousetrap question, the EST, the express sequence tag, the drug, right? Expression, copyright, invention, patent, can be owned. Facts can't be owned. Ideas can't be owned. So we wrap a thick layer of public domain around a thin layer of limited property rights. Then, because we're still worried about this, we add in all kinds of exemptions. Fair use. You can copy my stuff in order to parody it, or maybe to decompile my software to compete with me. Right? So we limit even those narrow rights that we give you. Okay? Then what we do, beside all of these other things, is we have time limits and say, and because we're pretty sure we may have got this wrong, after 20 years this goes into the public domain. And we also do things like publication requirements in patent. So the idea comes out and everyone can use it. So the way you should think of this system is a vast morass of public domain material which exists to support a tiny, thin, appropriately constrained and narrowly limited intellectual property rights. And that is a very decent working system, in my view. Unfortunately, we have begun to desert its basic premises for a variety of reasons which I'd be happy to deal with in questions. Intellectual property is moving closer and closer to the fact layer. Gene patents, in some cases, seem to me to be very close to a simple intellectual property right over an arrangement of facts. The idea layer is increasingly being taken on by things like business method patents, while changes in intellectual property right, which have been mobilized through the internet, the Digital Millennium Copyright Act and so forth, have impeded access to both the facts and to the ideas. I think that's a problem, and I'd be happy to talk about why it's a problem in questions. But let me turn to the genome. What may have been interesting to you is how totally different all of the things I've been talking about are from the controversies that you might have imagined were you to work in the ethics side or in the sort of warmer, mushier humanities side about human genome patenting. You might think that the questions about human genome patenting are none of the questions that have been addressed today at all. And some of you may be sitting there going, so far they haven't mentioned any of the things I thought would be questions. What are those questions? Well, they're hard to separate because they tend to generally come under the strong statement, you can't own a gene, which turns out to have 17 different meanings. The person who says, you can't own a gene, turns out to mean one of 17 different things. I'm not going to give you all 17, but I just want to run through some highlights. What do people more conventionally, people outside of this narrow world of intellectual property policy, a few economists, lawyers, some patent specialists, mean when they talk about the question of commodifying the genome and when they say you can't own a gene? The first objection is the objection of the sacred. You can't own a gene because it would be against the tenets of my faith. God wrote these lines of C, G, A, and T. It's heresy, or at least plagiarism, for you to claim to own them. And, in a more modest version, which I think some people would have more sort of non-religious people would have sympathy with, the claim is simply one of hubris. It's like, who are you to claim to own this thing which is, the human, a portion of the human genome? Second objection. I'm not going to give the responses to each of these, although, again, I'd be happy to go through them in the discussion. I want to focus in my comments rather more on the complete disjuncture between the academic world of debates about IP policy and these very strongly felt objections and the fact that the two rarely meet. So I'll get to that and then stop. The second is the sort of claim about the uncommodifiable, the idea that these are things that shouldn't be owned. There's certain things that shouldn't be owned, babies, votes shouldn't be able to be traded in the market, kidneys, right? Markets can go too far. The logic of the market, which I was praising so far, has to have limits. There are certain things we want to keep out of the market, and this is one of them. This is the danger of creeping propertization, property rights going everywhere. All kinds of different criticisms here, undermines the private sphere, disrupts our attitude towards the environment, leads to a corrupt and ultimately soulless society, leads everything to be run by economists. All kinds of very deep moral objections. Third objection. I should add in this one, the ultimate dystopian fantasy here is one where sort of subhuman transgenic creatures are sort of traded as chattels, Here's my little, helper, Chimpy, who's, got an IQ of 60 and is guaranteed by its owner never to form unions. This is a truly disturbing idea. I wrote about this in a book in 1996, and everyone said, oh, that's just so ridiculous. I think observing scientific progress, it's becoming rapidly less and less ridiculous and actually something we need to think about. The environmental ethic. You can't own a gene because if you try to own a gene, what you get is a system where the environment itself is parsed, isolated, manipulated, traded, and commodified in ways that lead us to intervene in the natural environment that ultimately will be truly disastrous. The idea here is not the patents themselves, but the patents become part of an economy which leads to all kinds of interventions in the natural environment for which we have very little data about what's actually going to happen. And the claim here is be a little more humble about what you can do. Be a little more humble about the natural environment. And I worry that by holding these very attractive patent rights out there, I'm encouraging a rush, not a rush to invest socially wasteful in resources, but a rush to bring technologies into play which will have environmental consequences which we know nothing. It's a different kind of claim, I think. Two more quickly. The common heritage of mankind. You can't alone own a gene because the genome belongs to all of us. It's the common heritage of mankind, like the deep seabed or the air above us, like the outer space. This is something which has to be owned by all, has a corollary or corollary, as you say so charmingly in this country, which is that if you have a system which allows the most technically advanced companies and hence nations to establish a private property right over a chunk of something which is the common heritage of humankind, you may be fencing off an entire portion of humanity who simply don't currently have the technological ability to establish those private property claims. Obviously, the limited time aspect of intellectual property in some senses makes it less worrisome in one way than establishing physical property over a similar kind of common heritage. There's also the question of the rights of sources. You can't own a gene because I own it. I owned it first because you took it from me or from my family or from the people who have my disease. And we should share in it. And the current intellectual property system, which as I've written in other work, tends to view the inventor as the sole source, the sole person entitled to the property right, and views the person who provides the raw material as literally just raw material, gives us little easy way to express our claims about the justice of those people's claims, either monetary or maybe just claims to control. I want to control the research. Now, I've rushed through these, and each one of them could take us through an entire conference discussion. In order to make the point that these discussions, which I think are very important, I think some of them are much more cogent than others, to be honest, but no pun intended, these objections are objections that you will simply never hear from patent lawyers or from intellectual property scholars. There is a kind of double-decker bus for gene policy. On the bottom is a rowdy crowd yelling, "You can't own a gene, it's, the common heritage of mankind, it's sacred, how can you possibly claim to do this? What about the environment?" And in the top is a much calmer, cooler discussion about incentives, about public goods problems, about the anti-commons effect, about, in other words, the kind of utilitarian arguments on which Alex concentrated and which I concentrated in the first portion of my talk. If you ask patent lawyers or IP scholars why they concentrate instead on questions about whether, a gene, whether the subject matter is truly novel or whether it's truly non-obvious or whether it's original, the legal criteria for patentability. Or on the other hand, on how will this impede follow-on research? Are you moving patents too far upstream, right? If you ask them why they do this, they'll say, well, for a couple of reasons. First is, I have no expertise in this other stuff. I mean, I don't know. How am I supposed to know if it's sacred? I don't. That's not my expertise. I can't add anything to that. It's not clear to me it's a terribly productive conversation. I do this really well. You as a society figure out what private property gets to cover, and I'll tell you how to define the private property rights on the stuff that you have decided to cover. If you want to say that you can't patent pinball machines, which they used to do because they weren't useful, because they led to the moral corruption of youth, which leads to fornication and eventually to dancing, then you say it. That's fine. That's your job. That's the Congress. But it's not my job as an IP scholar, okay? Nor as an economist. There's something to that. And God forbid we should have more lawyers and economists thinking that it's their job to talk about some new field. But the second thing they say is, look, this is a very important area with a lot of important economic consequences, and we're worried that this kind of you can't own a gene, bang, 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 is going to drown out the possibility of actually getting real drugs to real people with real diseases who are going to die while you're all yelling about how this is actually made by God, okay? And I worry about that too, so I'm going to concentrate on the innovation side. Both of those objections are very well taken. Nevertheless, I'm going to argue that we in the academy, we in the IP world, we in the patent law world and the copyright law world need to start thinking a little bit more about what's going on the bottom of the bus. Why? The first is that, and these are going to be very abbreviated. I'd be happy to fill them in because I got to finish up. The first is that our measures of social worth are demonstrably lacking. We measure the social worth of the stuff we're trying to encourage innovation in by ability and willingness to pay. According to our system, it is a fact that a cure for obesity or male pattern baldness is worth more than a cure for sleeping sickness, right? That's a fact. Now, that's not the fault of the drug company, okay? The drug company's simply following along the line of the system we've set up, which says something is worthwhile if I can give you an exclusion, a right to exclusion, to sell this product to people who have money to pay for it. Now, the fact that their kids are going to die in agony from the disease doesn't give them money to pay for it, so it is worth more for you to cure the cellulite problem than the dying problem, okay? There are very few economists even economists, who would say this is an adequate measure of social worth, okay? I mean, ability and willingness to pay is a palpably flawed metric. Yet we have set up our innovation system on it. It is our responsibility to start moving forward with alternative kinds of regimes of exactly the kind that Alex focused on, by the way, which try and supplement the current system we have, which try and offer other things. Prizes, for example, for the first people to come through with these kind of drugs. That's a moral imperative, and the fact that we haven't moved seriously enough towards it is an enormous condemnation of my profession in particular, but perhaps of the larger society. The second thing, some of the concerns being yelled about on the bottom of the bus turn out actually to be pretty close to our concerns. The people who are yelling about the environmental effects, just to give one example, aren't just worried about, I won't have any more trees to hug. They're making a cogent argument, which is, if you start handing out large monopolies, which people are really going to want to get, which is then going to encourage them to go and lobby people with large amounts of money, because legislators tend to be rather more moved by economic payments than economic arguments, right? Then you are setting in train a system which has built into it some what we call public choice failures. It's going to encourage the kind of decision-making which we as a larger society are not maybe going to like. That's the kind of concern we're actually pretty good at figuring out. That's the kind of system we ought to be thinking more about. So, does this tell us the possible limits of gene patenting? No, although my own view is that we've gone a little too far into the fact layer and the idea layer, and I'd be delighted to talk about it. Does it tell us how the system is currently working or not? No, for that we need a lot more empirical studies. I'm delighted to say that we have in the audience Wes Cohen, who we've been, since this conference was organized, we've been able to persuade to join us here at Duke, who's just written a fascinating paper on, for example, the way that licensing operates in patent cases, biotech patent cases, whether or not people can cross-license to cut down on the monopoly problems. Bob Cook-Deegan has a wonderful paper coming out on the CellPro case, which deals in a particular case with the same kinds of problems. We need these both individual case and empirical studies in order to figure out how the system's actually working. We need a lot more data. We need a lot more analysis. But we also, I would claim, need, as people who are thinking coolly and calmly about incentives, to take that first scary step on the spiral staircase that leads to the bottom part of the bus. Thank you.
Question, Lauren, can panelists speak from the microphones?
Yeah.
Okay. Oh, okay. I told you it wouldn't be boring. What do we have? Cockroaches, dancing. Max whispered to me, I think you whispered Viagra, in light of James's comments there. And as James pointed out, we don't have the sort of obvious disagreements that you might have expected here in terms of Max being the cold-eyed defender of patents and intellectual property, and others suggesting that this is a terrible thing and that we need to do away with it. We don't have that really at all here. I take it in some ways two different ways to go here on the questions. One is digging into those objections to what's been said here, and then pushing the panelists here on some of the alternatives that they have begun to sketch out, but haven't had time, having laid out their arguments, to go through. I have some questions more on the latter, but I think that in terms of order, there may be questions that address the former. And having said that, any question you want is welcome. Alan.
I'd just like to generalize the point that Professor Boyle made about the upper and lower deck. This is true throughout bioethics. It's true of cloning, for example. You get these radically different kinds of objections, whether it's coming from the public and the media or from scholars. And I think that bioethicists, of which I'm one, have done a bad job because we haven't attended to the lower deck. We've dismissed it as irrational. And I think that what's needed is to think more about the framework of public discourse, what Rawls calls public reason, and how we can make translations between these two sub-discourses. And I think that it's a huge mistake both for academics interested in these things and for industry to ignore or scoff at the lower deck rumblings. So I think you're making an excellent point, but I would just extend it across the board, not just for IP, but for genetic manipulations, genetically modified crops, producing human beings by cloning, virtually any sensitive issue in biotechnology has this same feature of a disconnect, and we ignore the lower deck at our peril.
If I could actually take Alan's question, Alex had mentioned to me, and I forgot, I should have, if the panelists want to respond both to Alan's point and to each other's right now, feel free. We've got half an hour, so I don't think we're running out of time right now. Alex, did you want to?
Well, I want to say one or two things, or maybe three. The first one is I'm glad I didn't take all my time. It was a pleasure to listen to Jamie talk about these things. The second is it's not clear to me by any means that the back of the bus or the lower deck is really being ignored in these public discussions. I've just spent 4 weeks worth of class working through the Nuffield Foundation's bioethics panel's recommendations on patenting genomic materials, and most of the considerations which they adduce are of the sort that Jamie mentions in his list. My own problem, and this is the third point I want to make, second point I want to make about this, is my own problem with these considerations from the back of the bus or the lower deck is they're almost always much too controversial a basis on which to secure agreement about matters of public policy. And that's one of the reasons why Rawls, who you invoked, excludes considerations, for example, from religion, from an important factor in deciding on the basic principles which we, behind the veil of ignorance, would establish for the control and the structure of the various institutions of our society. These issues are more of a public relations problem, a very serious public relations problem in convincing the society to adopt and embrace what we might, from the basis of other considerations, craft as the best solution to the public policy problems of not setting the barrier too low or setting it too high. And I would say the third point is that the one factor that, in my view, does provide a ceiling, and perhaps a low ceiling, but one that needs to be assessed on the patentability of gene sequences, is the problem of inventing around them. That there is something scientifically unique, not morally or ethically or socially or from the point of view of the sacred unique about gene sequences. There's something scientifically unique about them. The only method of faithfully encoding genetic information for hereditary transmission in our entire biosphere is the nucleic acid method. It's about the only feature of our biosphere where there's only one way to skin the cat. There's only one way, apparently, to do the job. And that one way suggests that maybe patenting is a problem here because there aren't alternatives.
If we can, are there other comments on, especially on this sort of, what is it, bottom of the bus, double-decker theme in terms of addressing these questions of commodification and environmental ethics and such, and whether we're doing that and how well? Yes, please.
Yeah, I'm really interested in hearing you say that. Maybe, Alex, these things aren't being ignored in ethical debates, but I think they're underanalyzed. And there are a number of us here from the English department who were nodding vigorously when you were making your comment. And I'm wondering how to incorporate cultural analysis more fully into ethical, legal, and political debates, which is what those of us here are doing. And I think my real question is, what would make you folks take us more seriously? What would we need to do to be able to enter that?
Gentlemen, Max?
I think you need to be careful how we define you folks. I'm fundamentally very scared that the numbers on the bottom of the bus largely outnumber the numbers on the top of the bus, and that the bottom of the bus is growing much faster, and that the people on the top of the bus have a very orderly paradigm for how markets work and what the rules are and all that, and we believe our own logic so well that of course we're right. But as America becomes a much more diverse nation driven by religious belief, the re-rise of fundamentalism and all these things, tell me they don't believe they're fully right and that we're way out of control wrong. I waited with bated breath to watch our president announce his decision on stem cells, and I've never seen a greater muddle in my life as what came out of that, because the cacophony on the bottom drove a lot of the decision. And it was, in the end, a political process that came forward, which underlies all of the laws that we work on. That in the end, if Congress believes that you can't patent it, you can't patent it. It's going to come forward in brute force political numbers. And I think our country is changing so fast in the beliefs, and it's not necessarily going to be a country of kind of intellectual, legal, gifted elites who are always going to make these rules. And it scares me because it catches me in midstream. Oh, you can't use those. Too bad. Bye. You can't do this. It's a different argument that we have to look at, too, I think.
Yeah. Is it, Priscilla, you want to come back? Yeah.
I mean that we're the people on the bottom of those.
No. I wasn't meaning to say that
meant
either.
We're analyzing. We're the
Sure.
people who are trying to explain where those beliefs and, in some cases, irrational anxieties are coming from. The literature and the film and the things in public debate, the popular press that are contributing to some of the rational and some of the irrational responses to these issues.
James, you gave us the metaphor, and you didn't seem to treat the commodification and other arguments as scary as Max finds them.
You mean scary in that they might sway people and that they would actually lead to policy implications?
The better calls.
That they're irrational,
Yeah.
and that we should be afraid of them.
I think that we need to.
I didn't say irrational.
No, but you said that there are two worlds that both believe in the coherence and self-centeredness of their own views, and I think that's largely true. I think that what we need to do is look at the past and try and take from that ways in which our understanding about rationality has actually changed in particular historical controversies, and that's partly my answer to you. That would be the longer answer. Think of the kinds of anti-industrialization critiques that you get in the 18 and 1900s, the Luddite kind of response. Think now of the portion. Is it true that we reject all of those? No. It's not true. We do reject, I think, some of the literal demonization, there's bad spirits in the machines kind of stuff. I think we see clearly the benefits to people, including the poor, of various forms of industrialization. Those ones, I think, are disposed of. There are, however, others which people writing at the time, Adam Smith, for example, that well-known acolyte of markets, talked about, namely that as you got a system which was more specialized and which was more driven by function with very high production in particular areas, that it would lead to alienation, it would lead to the separation of one from another. There is, I think, in the original critiques coming out of that, a strand that was picked up by the later environmental movement, which most of us would acknowledge is a really good point, right? So what I'm trying to do is say, if you just say, oh, they're all crazy, then you are doing something which we should know from looking at the past is a mistake. Because yes, it may well be that you say, I think some of these are just irrational, should be excluded on Rawlsian grounds or whatever your own particular criteria are. But in there are a lot of objections which I think have powerful distributional justice claims about, this is very good for whom exactly? Which is a concern which, as I suggested, we ignore at our peril, particularly given the skewed measure of social worth, which I think we adopt here. And also ideas which are actually quite subtle, carefully worked out notions about adopting a system which puts you on a track which takes you to places you might not want to go, which are things that economists, among others, should really be interested in. So I think the answer is that a lot more cross-historical research is particularly useful. We learn about the future by thinking about the past, but that's, I'm from Britain, so of course we say that.
Max did not say irrational, and I apologize for imputing that. On this subject? I just wondered if we've got a good one going, if we could stick to this for one moment. Yes?
I had a question for James Boyle. I was wondering if there's really such a distinction between the two sets of arguments, the IP set of arguments and the list you gave us. Because it seems to me that many of the arguments in the list you gave us, especially those relating to who really owns the gene, God, all of us, the person who is the resource, could go into the criterion of novelty in the IP argument.
Mm-hmm.
So,
yeah, I think that's the way that a lot of these arguments get made. I think you're absolutely right, is people take their deeply felt ethical objection and then come to the legal system and have what lawyers do for a living is fill conceptual boxes. That's all we do. All day long we fill conceptual boxes and send them out the door. And what they do is they bring in their ethical objection and say, I object to this because of this. And the lawyer goes, What you're saying is it's not truly novel, which is a requirement of the patent system, and so there's a conversion of one to the other. I think that goes on. I actually think that process of translation is actually very useful, right? That is to say, I think it's one of the ways that we filter these ideas back and forth between the systems. For purposes of what limited brevity I actually managed to achieve, I was trying to cut down on the various ways in which the two things intersect, but I think you make a very good point.
This is your point, Alan, about translation?
I think in some cases you need translation, in some cases you need a filter.
Mhm.
Alex was saying that certain kinds of slogans and complaints should not be given weight in public discourse concerning how you determine public policy. So I think the relationship between the two decks is very complex. In some cases, there's no translation that will make the message something that ought to be weighed, other than on public relations or
No,
strategic things, but it should not have any normative force. In other cases, it should have normative force, and you may be able to see that better by achieving the right kind of translation.
James?
Just one thing before, I think we should go on with the question, but before we finish, I'd love to hear from Max in particular, what changes, sort of moving a little bit from the question we're now looking at to
Right.
the second theme that you were talking
Yeah.
about, what changes as the CEO he thinks would be necessary in order to produce the flourishing genomics or whatever industry, because I think that might be an interesting loop back into the question that Alan was raising, because before we know the kinds of translations and filters that are necessary, we need to know what the people in the industry are actually going to be pushing for and lobbying for in the future.
Yeah.
But I mean, we can get to that at the
I
end.
think what I thought is we had half an hour. We're 10 minutes into the first, and if there's, on the general question we've been dealing with, and then we can shift to the consequences and just that, if there's more on this translation and filter level. Tracy?
This is, I guess, a question for Jamie. Jamie, you mentioned your concern about, I think, what are really distributional issues, and that is that we, in our economy, tend to value a good according to how much people are willing to pay for it. And you pointed out quite correctly that there's certain segments of our society who don't get to cast many votes. And so because of that, we get distortions in how we allocate resources, and we ignore people who just don't have votes. Now, it seems to me we could rectify that in a couple of different ways. We could, since we're here at a genomics conference, we could spend a lot of time talking about how genomics policy should address this issue. But if we were not at a genomics conference, but at an educational conference talking about what level of tuition to set at prestigious universities, someone would also come up with the observation that, well, there's a whole bunch of real smart people out there who will never get to go to Duke University, or it's unlikely they'll get to come here because they can't vote. Now, and we could also then ponder about, well, how should we adjust the tuition structure at Duke University to overcome these distributional issues? A third alternative is some people say we ought to separate these things. That when you concentrate on one good, like genomic research or drug or tuition at Duke University, and you try to make that good sort of rectify and remediate certain social inequalities, you're placing too much of a burden on that good, and you're basically distorting what you're asking that particular good to do vis-a-vis a bunch of other commodities in the economy for which you don't place that responsibility on them. So I'm wondering, and so then people have gone on to say, well, really the best way to do it is we'll let the government tax people, and then in their infinite wisdom, guided by public opinion, will allow them to redistribute the taxes to those people who sort of deserve them and got the short end of the stick. And so there's a separation principle that says, when it comes to producing commodities, just make sure they're produced at least cost, most efficiently, and then we'll solve all the other problems, the distributional issues, through some sort of public policy and taxation.
Yep.
James?
Well, let me just finish. The problem with the separation is that often you don't have enough faith that the distribution is actually going to occur, that people say it will occur, but in fact of matter, at the end of the day, there is no redistribution. And so I guess I'm not just asking you specifically, but I'm asking all of us at this conference to sort of ask themselves the question, before we decide that genomic innovation should solve all the problems of society and accomplish this wonderful redistribution, I think we should also be asking, for those of us who do want to see things redistributed, are there easier, less intrusive, less distortionary means to do that? You know, I would just hope that we ask that subsidiary question as well.
Right, and this is, I think, Alex has raised this as precisely the point, and does push toward what you were suggesting, James, this question of what are the alternatives if we're not messing around with IP. It's a question for Max you asked, and this is a broader question for both of you. So we've made the turn nicely here. Do you want to take that up first?
I think it's a beautiful. It was also one of the best phrased versions of that question. Tracy managed in a very few sentences to put an extraordinarily complicated and very powerful idea. One of the many reasons we're glad he has joined us here at Duke. I think that I have a very long and complicated answer, which I won't give, which says that the implicit idea underlying the separation of efficiency and equity needs to be questioned. That's, I think, really interesting and far beyond the subject of this conference. The pragmatic response, which I think is more productive, is to say, as you suggested in your comments, that while it's true that there's a lot to be said for saying, look, don't try and solve these things social good by social good, because you'll lead to an incredibly distorted thing where you're, handing out free education and food gets treated, which in exactly the way you described. I think there's a vast amount to be said for that. It's a really good point. It does point, I think, to the need to think more about distribution. I think in the innovation policy area, there are immediate moral claims of the type, I'm dying when you could cure me for very little money, that are being made to us, to which that response is an epistemologically and ethically thin response, right? That to say, it would be better all in all were we to be able to redistribute income globally, because we'd have to do it globally, not just societally, to solve these problems. In some abstract sense, I might say, you've got a really good point. So therefore, what I think I would say, and this is one of these kind of rebuilding the boat in the middle of the ocean, in order to convince people that the current system does have these holes where we really don't think that ability and willingness to pay is a good metric, one thing that you have to be able to do is to point them to examples where they go, oh yeah, even I would say, no, not here, okay? I think that there would be a sufficient social consensus to say that were we to establish what I think would be a relatively modest program concentrating, for example, on tropical diseases, not actually focusing on the genome here at all, but I'm talking about IP more generally, and establish either a set of prizes or a set of returns to producers based on the stuff they produce, and say, look, this is a way in which the market system didn't solve it. I would, while your comments about distortion are well taken, I wouldn't worry about them so much, because the need in particular, like I'm gonna die, seems a relatively intense one. And the result actually seems like something which might help move people towards the kind of broader discussion about redistribution that you yourself are suggesting would be more fruitful. So in this limited case, I would say maybe the two distinct problems you outlined are not as salient. And that with to put it another way, as one of my colleagues did, the great thing about IP is the current situation is so bad that almost anything we do will be better.
Good. Yes.
I guess a related question on the question of regimes of innovation, or how innovation happens. And earlier in your talk, James, you mentioned that, I think you mentioned, maybe I need to get a clarification, that Alex would produce things at the university without ever encountering the realm of IP. And I guess I was puzzled by that, because everything he writes probably is copywritten, and that prevents me from taking that paper and then reproducing it. And so, what did you,
without relying on IP as a major incentive. Alex's books and articles should, in fact, be blockbusters. People should be, ripping them off on the streets of New York. They should be in the front of borders. But at the moment, they're not.
My best book is number 46,000 on the Amazon. and that's the highest rated book in the philosophy of science that there is.
There you go. And it's a darn good 46,000 too. On the other hand, Alex's status in other metrics is much higher. So now it is true that intellectual property law is important. It helped to get the book distributed, and that was not trivial, right? So it's not so much in the incentive for him to produce it, but the incentive for the publisher to publish it, although it turns out there are interesting cross-subsidies there. I think that it's true that it would be relatively easy. There are a lot of problems we're discussing today that are really hard. It would actually be relatively easy to thrash out a policy for getting typical copyrighted expression produced in academia out to the public at basically its marginal cost without IP, right? I think we could do that here, right, without much of a real difficulty. I think it begets much harder when you're talking about the kind of stuff that Max was talking about, where you're not just talking about expression where I write it, that's the end, somebody else can build on it by simply reading the book or parodying it, whatever, but rather talking about moving a product to market. And that's the place where I think IP has the role to play. So what I was suggesting is Alex relies on the fact that people are impressed by him speaking, by his prestige in the academy, by the fact that his colleagues find that he's insightful, all kinds of little economies. He can, get to go to a nicer university, he can get time off teaching. These are all incentive systems, they all help him, but they have very little to do with intellectual property. My point was many of our systems for producing information goods similarly have very little to do with intellectual property. They're worth thinking about too, not just IP.
Yeah, and in fact, many of the problems of IP are just not problems about copyright at all. Okay, we tend to lump patent and copyright together when, in fact, the particular protections for copyright are easy to enforce, easy to recognize, and in the case of ideas which might be expressed in a wide variety of different ways, okay, copyright just won't work as a protection.
Mm-hmm.
Because, the whole music problem is copyright.
Oh.
So, in that sense, they're not always easy to protect. There's different, for us it is. Because
Right.
no one wants to-
Right. Wes?
Is it okay to switch subjects a
please.
bit now? Great. One, just a kind of a point of information, that other question. I didn't, Max made a provocative comment before, or a question. Are they useful in biotech? Okay. Just to report briefly, I've been involved in a research project trying to look very carefully at the net incentive effects of what you might call broadly patent effectiveness with regard to R&D for the entire U.S. manufacturing sector. And we were able to break out estimates for biotech, drugs, semiconductors, computers, and so on. In biotech and drugs, the effects are comparable, and they are vastly greater and on balance just clearly positive with regard to inducement of R&D. Now, that's not to say that patents are not also used as trophies, tools, bargaining chips, weapons, and so on. In fact, I'm quite in print in saying, remarking on just those functions of patents, but on balance, they have that positive incentive effect. Okay, just point of fact. Two, just broadly for the discussion here, we've been talking about, well, what are the trade-offs in biotechnology of making patents stronger, weaker, the bar too high, too low, et cetera. And sometimes this sort of discussion, and this becomes actually more salient when you look at other domains, other industries, that patents are not the only mechanism, and this is implicit in some of Alex's remark, for protecting invention, for protecting ideas. You have secrecy, you have exploitation of lead time advantages, exploitation of complementary capabilities. So when you talk about the possibility of weakening patents, one should recognize that firms will then not just necessarily stop inventing, but they may start using these other vehicles. Let's take secrecy, for
especially,
example. Okay.
Which many people claim is a more important strategy in biotech than patents.
In fact, well, in my own, I have estimates. I can, we can talk about some survey results of mine on just that specific question. They're a little underneath, but pretty comparable. Okay. But the point is in terms of social welfare impact, secrecy, for one, is really horrific compared to patents. So when we have this discussion of IP and the merits and the social effects and so on, we have to understand we're not going to control what these private firms and institutions do with these other things, which tend to exist outside of a formal legal structure for the most part, not entirely. So I just want to put that context here when we start talking about the trade-offs, et cetera, of stronger, weaker IP. And I had another question, which was just briefly, what do you guys mean by stronger, weaker IP, high bar, low bar? But that, I'll just leave that.
Max,
that
do you
open.
want to respond to this? Because it's similar to James' question. question about the alternatives.
Well, sure. We could not have done in any company I've been in what we've done without the protection of the patent laws with all of its manifestations we talked about, weapon, shield, everything else. The doomsday weapon of owning that controlling monopoly that you can wield against others to keep them out, because otherwise I wouldn't have gotten money and we couldn't have gone forward. I would say, though, that we have this unique capability in our company, for example, to slice brain, keep it alive, and insert genes in ways that nobody else can do it. And it's a multifaceted process. It lets us do functional genomics in living tissue. All my venture capitalists said, aren't you going to patent that process? I said, if I patent that process, I basically taught everyone reasonably schooled in the art how to do exactly that, and that I'll never see them do it. That it will be done in laboratories in London that we'll never know, and a product will emerge that goes after our same targets, and I won't know how they got there, so I won't know to sue to stop them. So what we wound up doing is not patenting our process at all, but implementing a regime of secrecy with occasional ripstop patents, so that, they're like those things you back over at the car rental place. Back over this and I'll shred your tires. And if they hit those little ripstops, they gotta stop. But by publishing then, I don't at least clue them in to how to connect all the dots it took us 20 years to connect. So
every economist will tell you that this is, on the whole, bad for the society as a whole, because it results in overinvestment by his competitors and underinvestment by people who know that others will rip off their idea.
Mm-hmm.
I think, I'm sorry, can I just respond? I think Wes's point is particularly well taken, because one of the frustrating things sometimes about this debate is that people assume that the alternative to patenting is that everything is just there and it's free and it's wonderful and lovely. And that, of course, is not the case. Now, there is a reason, I think, why in some cases that is posed with the gene patent world, why people don't spend as much attention as they should on the secrecy option. And that is its foundation as a public domain genome initiative, in which a lot of stuff was being put forward, and where the claim, had you not patented this, it would have been public, had more force. So it's, I think, a contextual point. But in general, the idea that, no patent therefore equals greater access, I mean, you simply have to look, the economists love looking at the structure of the feudal or medieval guilds, where you have, instead of relying on legal exclusion, you simply rely on saying that to your apprentices, if you reveal this, we'll kill you. Hence we still
that is
don't.
what we say.
You could try that, Max.
And hence, you don't have to reveal that. And hence, we still don't know how to make Stradivarius violins, because, that secret died with the people who put it forward. So there are enormous costs here, which should not be underestimated. However, I do think that genomics has some specific features that are worth bearing in mind there.
Alex has a comment, and then there's a question back here.
Oh, I was only going to point out that the reason that the government was induced to provide the 3 billion base pairs was because it wasn't patentable, and those in whose interest it was to have these base pairs recognized that they could not invest in production of the 3 billion base pairs because there was no return to them available. So they convinced the government to provide it for them.
I have a question about gene patenting in general, the question of novelty. I think it's really interesting how patent lawyers and biotech companies have been able to get around the question of novelty by arguing that by manipulating the genome and adding certain primers and putting them in plasmids, they've created a gene in a state that it doesn't exist in nature and are able to get around this. And my question is, there's whole biotech companies that have sprung up with the sole purpose of sequencing genes and filing for patents as fast as they can. It's too bad Dr. Bennett is not here to speak on this issue. But I know that several of these genes have in fact been patented. And I'm just wondering if we were to decide that patenting genes is actually at a level that's too high, what will happen to these patents that already exist, and what's likely to happen? And how could we prevent that without changing the criteria for patents?
Great question. You want to lead off on this one, Mike?
No. Well, from a general point of view, speaking as a professor of law, from a general point of view, we know already that in our legal culture, ex post facto legislation, is prohibited, and so we couldn't expropriate these patents from those to whom they'd already been given. But we certainly could change the general regime, and indeed, if you follow the details, you know that over the last 10 years, the U.S. Patent Office has significantly changed the regime and raised the hurdles that are required to be surmounted in order to secure a sequence patent. Whereas 20 years ago or 10 years ago, you had only to identify the functional genomic unit primary sequence in order to get a patent. That is no longer anywhere near like enough. And presumably over time, the patent system varies in order to maximize the social benefit of innovation, but always with a lag.
Well, it's clearly evolved because you've seen this utility standard change so dramatically, but it's also funny. I mean, we were a functional genomics company. We had the ability to absolutely identify utility of genes in the brain that nobody else could see, and we spent 2 years and lots of millions of dollars doing that, and everybody said, but I'm not paying you for that, because really what we want are drugs. So how are those going to get you to drugs? And all the money we spent on functional genomics patents basically was a waste.
And why
You know,
couldn't
we
you
might as well
sell?
publish.
Why couldn't you sell that information to big pharma?
Because so many people said they had it. There is a sea of that type of data out in there, and what we've now had to go do is say, well, we imputed that it would have this function, but is it really implicatable in a complex cascade of brain disease? And if you intervened here, would it yield a drug that will be useful to them that they can sell? And I have to demonstrate first principle that I can actually manipulate that with a compound that they can make and sell to somebody before they'll buy anything that comes out of my system.
And this sounds as though it's the admission that the scientifically important breakthroughs that your company undertook wouldn't satisfy the patent office's requirement of utility. Because in and by themselves, they would not provide the basis for the formulation or even the identification of a protein that made a difference to cognitive function.
Well, the mere fact that you find a protein doesn't mean you can manipulate it in a way that it becomes a product. So you could satisfy utility without in any way demonstrating you have something anybody will buy. I mean, we went back to this. The measure is dinero, you know, that somebody's going to pay you for it. And a lot of the art, you know, it's the petunia argument. Will you pay me for petunias versus lettuce? They won't pay for functional gene sequences unless you can show that in a narrow time frame that affects, it's that line from Mel Brooks' Blazing Saddles. We're talking about our phony baloney jobs here, gentlemen. That they want something close to market that'll affect their share price through their earnings, because that's how they retain their jobs. They ain't paying for something that'll reward them 10 years down road unless they're absolutely visionary and unless it's only a very small part of their income stream.
Just responding also, very, very good question, excellent responses. The legal response, speaking also as a professor of law here.
That's why I said no.
It is possible that the Supreme Court could review the patents that have been granted and could say that the standard of novelty is not met and that it's a constitutional requirement. There is a strong argument that it is a constitutional requirement. The Supreme Court, in fact, has said it's a constitutional requirement, and that calling this level novelty may actually violate the Constitution, that the Congress is doing something it doesn't have the power. So I could craft you a very nice legal argument, which would be technically, you know, would pass muster. People wouldn't, you know, say, that's ludicrous. They'd say, yeah, you know, you have some good points there. Your question was, what would happen? Okay.
I recall reading a case about, I think it's the University of Rochester, and some researchers had patented gene, and there's a painkiller directed at those, and they're facing a big, huge lawsuit to, you know,
POX2, yeah. Yeah, and I think we actually have an example about what would happen, and the example is that what happened when Tony Blair and Bill Clinton said, well, of course you can't patent genes. Someone had just kind of, you know, told them you couldn't, I guess. And the, how much did the biotech NASDAQ lose of its value?
Oh, half.
Half.
Solera lost half its value in that one day.
In the next day, bang, 50% wiped out. Now, while it may not be true that the Supreme Court follows the election returns, nor that the Supreme Court actually decides the election returns.
Actually.
It is, Alex, you stole my line and I own it.
Re-elect Gore in 04.
It is, however, the case that I think the Supreme Court would look at this market, which has been built around this multi-billion, now fewer multi-billion, but still multi-billion-dollar market that has been built around the assumptions, the fundamental assumptions, that there are fairly basic gene patents available. Now, maybe that was a good decision as a matter of economic policy. Maybe it wasn't. We can debate that. Maybe it was a good interpretation of the novelty and originality and et cetera requirements, and we can debate that. I don't see the Supreme Court tomorrow going and making all the stuff that he's talking about vaporize. I just think that that is politically and judicially inconceivable. So I think what you're likely to see is much more the kind of tinkering that they were talking about, where the utility guidelines get tweaked or novelty gets reinterpreted, partly because technology does actually redefine for us both what is useful, what is novel, what is, and particularly what is obvious. I had a wonderful debate in my intellectual property class where people would stand up and go, "Oh no, doing the sequencing is an art," and and luckily there are many PhD students in my PhDs in my class, and someone would say, "Ah, come on, it's something high school students can do without even looking now." It's sort of, it's easy. How can you say it's? And so these debates about all the patent criteria are where we'll see action, but it won't be the kind of action I think that you were suggesting, where we just simply go, boom, and suddenly they all vaporize.
This is a question that will appropriately be asked of Amartya Rai on Saturday morning, I think, because she has, in fact, from this very podium, addressed the question on a previous occasion and made suggestions for how the NIH ought to act in order to ensure that the outcome that you described can be avoided. March-in rights that the NIH now has and doesn't use.
So come for that panel. Come to Dr. Venture's lecture this evening and ask that question. Just two brief things, and then we're done for lunch, I believe. There were clearly two broad issues on the table here, one of which we've just been taking up in terms of, in a sense, alternative to patents and different ways of thinking about that, that Max put on the table so clearly and that everyone has taken up. And that, I take it, is going to be pursued quite vigorously in many ways throughout the rest of the conference these 2 days. The other question, which we started with, which James got on the table with his bus metaphor, which is both wonderfully useful and also we got to be a little careful with, as I'm sure you'd be the first to recognize, and that Alan picked up on. And I would just take this 1 second to make this plea that for all the work that we're doing here in the center and in the Keenan Institute for Ethics, and even on the task force here in North Carolina that Lauren runs and that Donna is shepherding, this question of those who have concerns from religious, secular, sacred, environmental, commodified, and others, that this should be a discussion amongst us and not of those of us here talking about other folks there, and that there's some real opportunities. This came up in the first task force meeting about how to engage others in this process and not just the, and I mean this in a nice way, usual suspects around the table here. And I think we have a real opportunity in this state and with the organizations we have here to actually lead that kind of conversation and not just have two groups talking amongst themselves. Thank you all very much. We have lunch.
I really enjoyed it. You're going to have